One of the great ambitions for any genealogist is to try and find a gateway ancestor, somebody who is well known enough about that allows you to tap into a well-established pedigree, a fast track if you like, back into medieval or early modern ancestors. If possible, this will be a blue-blooded ancestor, so you can tap into royal genealogy, as we've seen on a number of occasions on Who Do You Think You Are, Matthew Pinson perhaps being the most celebrated example. However, it isn't as easy as we're led to believe perhaps on television. And what I want to do in this session is to provide you with a reality check at first, and then some tips and tricks to get you into the records, which do exist in vast numbers, but do also require a little bit of skill to unpick them, to understand what they say, and also to assemble them. It's not the same as modern genealogy. So I'm going to start with some of the practical information, the do's, the don'ts, and maybe some of the reality checks that mean you cannot go any further back in time. And then I'll look at some of the structures of the medieval world. It's vastly different to anything we know about when we go tracing our modern, Victorian, or even 18th century ancestors. It's a very different world. And as a result, the records are going to be different as well. You have to think in terms of top-level government sources and also the way local administrations work, different elements and different ways in which your ancestor may have interacted with both of these. And a large number of records will have been created through the processes of law and justice. There are less ways people would have left a mark in the records. And often, quite sadly, also quite interestingly, it will be when they fall foul of the law. So let's start with the practical stuff. And in many ways, these are some top tips to think about before you really even get started. Even more so than working on modern genealogy, you need to know where your ancestors lived. In many ways, the journey through life was incredibly local. You tended not to stray more than 10 miles from where you were born, throughout your married life, and indeed when you were died. Hatched, matched and dispatched in many ways. And this takes place at a parochial, or as we'll come to find a bit later, a manorial level. So knowing where your ancestors lived is really important, because the catchment area where you'll need to look isn't going to be that large. You also need to work back in time from known sources, particularly the things that perhaps you're already familiar with, which do provide a continuity through this period. The records of probate, or indeed parish registers, introduced 1536 but surviving in larger numbers for England certainly from the 1620s, or the old parish registers which are online for Scotland from 1554 onwards. But a lot of what you can achieve will be based on the status or indeed the wealth of your ancestors. Not everybody can trace their family back because the records start to fall away at different levels of society. You're most likely to find someone in the records if they are of a higher status, if they perhaps own or are linked to a piece of land, or they have a trade that generates enough material so that they appear in, for example, guild records. So status is going to be really important when trying to work further and further back in time. And I guess this last point really is to dampen down expectations still further. It's not always going to be possible to positively identify one of your ancestors. The further back you go, the fewer corroborating sources there are likely to be. So you may well already have encountered frustration when working through parish registers to find that there are several different branches of the family with the same surname, using similar Christian names generation after generation, and it can be virtually impossible to untangle some of these records. Whilst we're on a bit of a downer, let's have a look at some further problems. The first one is language. Now, Latin was the official language of medieval government. This was mainly because the people who worked to create the records had a clerical and ecclesiastical training, and Latin was the language of the church. It was also the language of many of the law courts, and so you find that most official records are going to be in Latin. You might find one or two pieces written in English, but English itself tended not to be used in higher elements of society until the late 14th and early 15th century. And even then, as we'll come to see, the spelling will be wildly different to what we would imagine modern English to be today. And there's also a problem of Anglo-Norman French, which was used in court circles, so that will be the king and the various hierarchies that would interact with the king's court, but increasingly lower down the social order as well, as the gentry tried to emulate their aristocratic betters and would deploy French in written communication. So you are going to have to start to learn new language skills. Now don't worry, it's not as frightening as it might seem. The Latin that was used in many of the court records was very formulaic, and there are spells when you can use comparator documents to work out the structure of material. So most Latin was abolished in the courts from the 1730s onwards. So if you are working earlier than that, just look at a later document and you should see the same structure, the same words appearing but in translation. And there was also a period from the 1650s until 1660 when English was made by decree of the Commonwealth under the Lord Protector, Oliver Cromwell, to be the language of government. So you'll also find a little pocket, a 10-year period there, when most records are in English. So you can use these as examples of the sorts of sources that you may well encounter your ancestral names. Being very formulaic, there may only be 5-10 different sorts of documents you'd need to have a look at. And there are various written texts that will introduce these to you, again, in translation. Eileen Gooder's book, Latin for Local Historians, is an excellent introduction, which includes formularies or styles of document deconstructed so you can pick out the key Latin phrases and how they're then translated. So most of the time there will be help to get you through. And when you are working with these materials, bearing in mind that very few are digitised, you'll need to go to the relevant archive where they will have palaeographical and Latin dictionaries, or indeed Anglo-French dictionaries as well. So ask for help if you are getting stuck with the language. Equally, although, the handwriting can be quite difficult to decipher. We call this palaeography, or the way documents were written, the particular hands that changed over time. Many of the state documents created by the King's Chancery or Exchequer, terms I'll come back to later, remained fairly unchanged, but you will find that they were heavily abbreviated, particularly the word endings in Latin, which will tell you a little bit more about the structure of the sentence. And of course these records were written many hundreds of years ago and can often become illegible or faded. And spelling will also be quite irregular. Even though scribes are copying year after year from the same base text, they may well also have had trouble reading their predecessors' hands and introduce their own interpretation of what a word should say. This leads to difficulties in distinguishing letters, C's and T's, B's and V's, and if you have a word with lots of I's, M's and M's together, it can be very hard to work out where one letter starts and the next stops. So again, it's not just the language, it's the actual handwriting itself that may pose you some problems. And so we have got various online solutions. The National Archives has put together a palaeography course, which will introduce the main sorts of handwriting, plus also the abbreviations and how they are extended so that you can then translate them. And there's also an Anglo-Norman palaeographical resource as well that's mentioned on the slide. But there are some books which will be invaluable in your research. So alongside Gooder's Latin for Local Historians, you should use Trice Martin's The Record Interpreter, again available in most archives. And this will give you another sort of formulary, all the key words with the standard abbreviations that have been used in texts over the last 500-600 years or so. So these are standard tools that will allow you to interpret what the documents actually say. Now we're obviously looking at names, but equally there are problems in recording names in these documents as well. One of the key points to remember is that surnames were only really introduced from the 14th century onwards for tax purposes. The poll tax in the reign of Richard II required people to identify who they were and often where they were from, so they weren't double counted, but more usually so that they didn't evade the tax assessors as they went round the country. So you start to get surnames becoming hereditary from this period onwards. But as a result, they were quite fluid in these early days. So in the example here, someone might consider to be called Geoffrey Luttrell may also be from Nottingham, so it could be called Geoffrey of Nottingham. But we also know that he was a mercer involved in trade, so it could be Geoffrey le Mercer, Geoffrey the Mercer of Nottingham, or any combination of these variants. So you may well find people described differently in different documents, adding to the complication about making that positive identification that I mentioned earlier. You may also find that there are abbreviated first names and Latin is used interchangeably. So Johannes instead of John, Ricardus or just Rix for Richard. And equally you will find variant spellings depending on whether it's been anglicised, written in French or indeed in Latin. So chambers or chambre or de camera if you wanted to look at the Latin version. So all of these things need to be taken into account when you are trying to identify an individual. This also applies to where you look as well. And making sure you've got the right person also depends on where they are based. And sometimes you may discard a key individual because you think the spelling suggests it's an alternative place. But as we see in this first example, scribes were very free and easy when it came to fixing place names. So personal names were fluid, so were place names as well. So the Place Name Society volumes will help you identify variants or indeed the earliest time a place appears in the record. Nottingham is a great example. All of these different variants, I like Snottingham perhaps the best, or Snot. So this would have been used interchangeably in the records. Places would also change depending on their status. So Lynn, once it becomes a royal manor, becomes King's Lynn in the 16th century. And you'll also find translations affecting the way a record is created. So Parva for little, Magna for great. So keep looking if you're not sure it's the right one. You might need to go forwards or backwards in the record to see if it appears in different ways in the same place. If this wasn't enough, we've also got dating worries. And this is because there was no exact same form of dating a document throughout history. You have a variety of different ways of recording dates. And the system we're used to today, the AD system, so 2016, was very different. And quite often you will find that the regnal year, based on the exact date that a monarch ascended to the throne, was used to record the date of that document for official purposes. So an example from my own period, 9 Henry III relates to 1225, but it doesn't precisely relate to 1225 because Henry ascends the throne towards the end of the year in October. So 9 Henry III covers the end of 1225, but into 1226 until you get to the anniversary of his accession to the throne, when 10 Henry III would then begin. And these, of course, will change because monarchs never ascended at exactly the same time. But this will change throughout Europe. When you look at papal documents sent from the Curie in Rome, you will have the beginning of that pope's reign recorded. And this is often the case when you're looking at some of the jurisdictions in England. So we have palatinates, which were semi-independent areas, and the duke who looked after that palatinate would assign their own system of dating. So it can get quite confusing. Equally, you will find, because these are often written by clerics, they used ecclesiastical dates to give a fixed point in time. So they may not say 25th of March, they may well say 3 days after Easter. And feast days were particularly important. So if you were looking at a financial period, the Michaelmas term was really important as well. Michaelmas was celebrating the feast day of St. Michael on the 29th of September. And most of the sheriffs would come to deposit their cash in the exchequer the day after. So this was Incrastano die Sancta Michaelis. So it can get quite complicated trying to work out when stuff was happening. So Incrastino die Sancta Michaelis, Regno Nono Henrico Tercio, a very long-winded Latin way of saying the 30th of September 1226. Now all of this can be resolved quite easily by looking at Cheney's Handbook of Dates. And this summarises all of the things together in one place. It will give you a list of all of these ecclesiastical feast days. It gives you tables showing you when each regnal year started and stopped. And it will also give you the date of Easter, which as we know is a movable feast. And it helps to resolve some strange dating before we switch from the Julian to the Gregorian calendar, where the start of the year was not the 1st of January, but the 25th of March. So all of these problems are resolved in Cheney's Handbook of Dates. So if you're not quite sure what you're reading, have a look at that and it will give you a modern date equivalent. Having covered those problems, it's time to look at some of the records where you will find your ancestors. And the first thing really to bear in mind is that we need to understand the way society worked And the mechanism by which people were administered at a local level and therefore were surfaced in the records was through the feudal system, introduced after the Norman conquest in 1066, which established a hierarchy, a class structure, if you like, which involved transactions between the levels based around land. So we're just going to have a little look about what the feudal system meant, how land transactions were governed, and what this meant for the actual class structure itself, how your ancestors would fit into it. This might be a document or certainly a diagram that you're familiar with. It is a rough depiction of the European feudal system. Medieval historians will hate this, but it serves a good purpose to show that at the top is the king. So, William the Conqueror takes over all the land after the Battle of Hastings. And to reward his noble followers, he parcels out chunks, keeping a large part to himself, which we now call the royal domain. In rewarding his followers, he gives land in return for service, so they have bonds of allegiance to the king, usually the requirement to serve in his army for a certain amount of time, and bring with them large number of troops. This is in many ways a feudal contract. The king gives land to his tenants-in-chief, these main followers, and they perform service in return. And this process is repeated all the way down. These leading nobles, these tenants-in-chief, have their own followers to reward. So out of the land that they're given by the king, they then give land to their chief followers, and so on and so forth, until you get to the knights, who are often then contracted by the lesser nobility to fight and serve. They are in many ways the administrative class of society. They might hold a bit of land, but they tend to perform basic functions at a local level. They might be empanelled to serve on juries, which will generate a record. They might be brought in as stewards to administer a lord of the manor's court, so they will leave records. They will be required to serve in the feudal host as men-at-arms, so they will generate a record. This is in many ways the bottom rung of the ladder, where you're going to find lots of information about people. Below that, where you get the vast majority of people who lived throughout the medieval and early modern period, you will find the peasants, who are subservient to this system and may only ever appear in interactions on an occasional basis. And unfortunately, this is where quite a lot of our ancestors may well appear. So these sorts of records are very hard to find. So it's really the top two middle bits, nobles and knights, where you find really good records starting to appear. Now, to understand the system, you need to understand a little bit more about the manorial structure itself. Most people lived in, or were bound to, a manor. They were bound to the manor by a series of customs or ties. Manors could straddle a large or small geographical area. Many people say that it's the same as a parish, but this is confusing. You may well have an ecclesiastical parish which has several manors in it, or one manor that straddles several parishes. In many ways, the only thing that ties people to the manor is holding land from the lord according to the customs of that manor. And there are all sorts of books and guides that will help you understand this. It's basically a microcosm of the bigger feudal system. The lord of the manor holds all the land in that manor. He keeps some for himself, which is the lord's domain, and usually he will live at the manor house or the capital messuage, the chief property. He will usually hire a steward to administer the customs of the manor. Each manor will have its own laws and customs, and the way in which people held land was particularly important. Here we have an ecclesiastical manor, and so it was bound very much by the rules of the church. This is Laleham in Surrey. And you can see the importance of the church here, because you've got the large monastery which owned the land, and various structures such as the tithe barn, the watermill, the bridge over which people would pay tolls, and then right at the top corner, the village of Laleham, the people who would then pay their money into the church, with these large fields providing support for them as well. The mechanism for administering the customs of the manor was through the manorial court, and there will be several different courts held throughout the year. Perhaps one of the most interesting was the court leet, because this bound all tenants of the manor, whether they were free or customary, and I'll come on to those terms in a minute, to a series of what I would call common law rules and regulations. So if you fell foul of these regulations, you would be brought before the court leet, and therefore your name will appear in the records, regardless of your status, whether you trespassed on someone's land or perhaps took some of the Lord's domain land to cultivate. If you owed money to individuals within the manor, you would then be asked to come forward and pay those debts off. Unruly neighbours are a common cause of disturbance in the manorial life, and so they'd be called to pay money if they had been found to breach the terms of their landholding. Things such as petty theft or poaching, all of these were dealt with locally, and so a wide variety of people would be caught up within the system. And this is where you may find some of the lower ranks of society starting to appear. But equally, you have a really important role where land was passed from one person to the next, according to the court baron. This would uphold the customs and laws of the manor, including the admission and surrender of copyhold tenants. Now, this is where we have a slightly complicated system of landholding. Some manorial tenants held their land free of the customs, and that meant that if they wanted to pass land from one generation to the next, they did not have to come to the court and ask the Lord's permission to do so. And they were known as freehold tenants. This is where freehold land comes from. They could buy or sell or pass it to the next of kin independently. However, there was another category of tenant called copyhold, and they were bound by the customs of the manor. This meant that when a customary tenant died, the land that they held was surrendered to the lord of the manor to be administered to the next individual. This was usually the heir at law, the eldest son, and they would have to appear before the court and then be admitted as the next customary tenant. And this process was then enrolled on the court rolls themselves. And the person was said to hold their land because they held a copy of this court roll. This is where you get the concept of copyhold land. Now, it is complicated, but it's vitally important if you're trying to track medieval or early modern ancestors, because if they were copyhold tenants, there is every chance that you will find them in the court rolls. The rolls themselves survive in huge numbers way back to as early as the 12th, 13th century. But the great thing is this system continued right up to modern times. Copyhold land was still transferred in manorial courts up to 1925. Now, a lot of the 19th century manorial courts started to wind down their business and people could buy their exemption from the system, but a lot didn't. And so if you are looking for your ancestors, say from a tithe map, and that you can identify that they held some copyhold land, you can immediately go to the court rolls and see if you can find their entry. And because of the way the court rolls were constructed, they will always tell you the date when they were first admitted, which allows you to jump back to the previous court roll, and that will tell you the name of the previous tenant, usually an ancestor. So finding an ancestor who is a copyhold tenant is an express way back into the records, allowing you to go stepping stone approach further and further until you can find the beginning of your ancestral trail. These are the most likely records to record your ancestor's name. Here are some court rolls, quite indistinguishable, but the great thing about them is that they also include the jurors of each court, and the jurors were the freeholders. So even if you have an ancestor who is a freehold tenant, you will find their name recorded in every court roll for as long as they continue to be a freeholder of the manor. Now, alongside these name-rich records, you will also find a variety of other useful documents created by the lord of the manor to help them administer the land, surveys in particular, which often just summarised all of the tenants at freehold, copyhold or leasehold who had bought leases of domain land from the lord of the manor, various extents or terriers, just really inquiries trying to work out who held land on what terms for how much money. So they're a great way, if they survive, of just having a snapshot of who was working or held land in the manor at that time. And this is where you'll also find lots of names of ancestors. And there's also a very strong financial set of records, the accounts, which could include incidental expenses on repairing or upkeeping property, which will include the name of the tenant. So look out for surveys and look out for accounts. And there is an account roll. Again, it's quite difficult to see, but there are various records for the disbursements of land, including the names of the tenants of each piece of land as well. Now, where would you find these records? Well, you've got the Manorial Documents Register, and as you can see there, created in 1924, a lot of it has been digitised. And if you go to the National Archives, you can search for access for where these records are. Those that haven't been digitised, you will find on film at the National Archives. The great thing is that they will tell you the location of every court roll and a whole range of other associated manorial material, plus the references that you'd need to find it. So it's a really great snapshot to locate the records. Now, a quick word about how you would track your freehold ancestors. This was usually through the process of conveyance. We're familiar with modern conveyance, where you go in and get a mortgage and spend vast amounts of time paying it off. But back in the medieval time, there were a whole series of devices to convey property from one person to the next. And because these were individual transactions, they're very hard to find in official records. But a lot of people were concerned in case these records were lost, so they went to great lengths to create an official copy. Individual title deeds or conveyances can be found in private collections or county archives, but you will also find enrolments where people paid money to have that process recorded on an official record. Many of these have been written on the back of a series of records at the National Archives called close rolls. People paid money and there were indexes created for these, or indeed on charter rolls. Those are the record series C54, C53, and there's information online about how to find out more about them. But other people went to great lengths to create almost fictitious lawsuits where the purchaser and the seller would go to court and pretend that they were at dispute about the value of the exchange, and a legal judgment would be created, and a 3-part document would be drawn up summarising the agreement. This would then be detached in a particular way from each other. One part would go to the purchaser, one to the vendor, and the third part, the foot of this agreement, would be enrolled in the Court of Common Pleas. This would be the foot of the final concord, or fine. And they were cut in such a way that they could only be put back together if each part was unique. This was an attempt to stop forgery, and they were cut with particular teeth marks, or indentures, and this is where the legal phrase indenture comes from. So the feat of fines, these court records showing you property transaction, will be full of people's names. They start in the late 12th century and they run right the way through into the 18th or 19th. These records are available at the National Archives, but many local record societies have transcribed them. There is an example of the foot of fine. You can see the wavy teeth marks at the top. They were also chirographed or written across. So again, when you fitted all the bits together, only the valid copy would look right. So it was really an attempt to stop forgery. Now, I talked a bit about the social hierarchy, and many people in the 16th century wanted to bear arms, armigerous ancestors. The important thing is to remember that this was awarded to an individual, but the whole process of becoming a knight or entering the squirearchy was a symbol of status. People aspired to this. In many ways, the birth of genealogy as we know it today took place in the Tudor period, when people wanted to become a knight. They wanted to show a pedigree, to show their stature. And this was such a big issue that the Crown sent its heralds round to each county to check the validity of the evidence. Now, many people just paid off the heralds to have their almost falsified family trees recorded. But what we do have are the records of these visitations, held every 30 years or so. They were now collected by the College of Arms and have been published by the Harleian Society. There are also a range of different unpublished pedigrees scattered around the country. British Library, Society of Genealogists, they actively acquire, but also buried within the records of places like the National Archives or local record offices. And these have been used to publish validated pedigrees or family histories, such as Burke's Peerage, Debrett's, The Complete Peerage of England. This is where you will find a gateway ancestor, someone whose pedigree has been validated by one of these processes, so that you can trust what's been written. If you can find a link into one of these, the chances are you will have a pedigree that goes back many generations. Here we find an example of a record that you would not normally expect to find. It is clearly a pedigree, but it's being used in a court case to prove inheritance. So you've got all the generations. Moving on to some of the records at the top and also a local level, the records of government. This was an important part of the medieval world. So at the ground level, you've got the manor administering the daily lives of individuals, but you've also got the crown and central government taking a vested interest in what was happening. Now I'm going to talk a little bit about some of the institutions, the chancery, the writing house of the crown, and the exchequer, which dealt with money flowing in and the audit process, as well as the mechanism for capturing opinion, council and parliament. But equally the infrastructure of officials that operated at a central and a local level. Royal officials, but also some of the activities they undertook, such as inquiries into local levels, and how crown lands were managed, as well as some of these semi-autonomous jurisdictions I mentioned earlier, such as the Palatinates. The Chancery recorded 3 main areas of interaction, which I think would be useful if you're tracking ancestors. And it dealt with instructions being sent out from the centre to individuals at the local level. There were 2 main sorts of instruction that went out. One under a letter patent. This was an instruction or something sent out to a local official that was intended for everybody to have a look at. It was effectively an open letter. And a seal, or a mark of authenticity, was appended to the bottom, hanging or pendant, and therefore it was already open for everyone to see. A copy of that instruction was also kept at the centre, recorded on a patent roll, effectively making sure that the information had been sent and to whom it was sent. Equally though, there were more private instructions sent out to individuals, and these were closed, where the seal was actually attached into the document. You had to break it open to see the contents. So these closed records were also copied into central rolls. This is where you get close rolls versus patent rolls. And they are stuffed full of names. Thousands of names each year of people receiving this information or the subject of these inquiries or instructions. Most of these early records, and they are very early, from the 13th century, have been calendared or summarised and printed with indexes at the back. Most research libraries will have a copy. The National Archives, where these records are kept, will also have copies, as well as the originals. And it is worth pointing out that these aren't just medieval sources. They go right the way, in the case of the patent rolls, to the present day. They're still being created. Fine rolls are an interesting beast. They record offerings made by members of the local society to the crown for various reasons, either to gain appointment or to secure a writ of justice, or simply to seek favour. And so in many ways it's the opposite side of the conversation. These were of course then recorded so that there's a record of what was received by the Chancery. So you have fine rolls stretching from 1199 to 1641, key date because that's the start of the Civil War, when this system was pretty much disbanded. The Exchequer dealt with financial matters. It audited revenue coming into the centre, but also any expenditure authorised by the Crown in the locality as well, summarised in pipe rolls. Again, the Pipe Roll Society has produced transcripts of many of these records up to the 1220s, and they exist in their original format up to the 1830s as well, alongside memoranda rolls which recorded the detailed business of government and the financial conversations from 1218 pretty much to the present day. These have an incredible insight into the people that were being discussed, crown debtors, and how much money should be taken from them. And as a result, you can get a real insight into what your ancestors were being called to account for. Equally, many people were called up for taxation purposes, and you have detailed records, parish by parish, of who owed tax to the centre. Now the tax rates were really quite generous, 1/10, 1/15, 10% or less, but it did cause a lot of controversy and many people tried to avoid paying tax. Nothing changes, I guess, but we do have the names of the taxpayers on point of assessment or exemption in record series E179. There's a fantastic database that allows you to search by parish or place, by period, and they will identify which records contain the names of individuals. That's also available online via the National Archives website, and you will find many local record societies have printed transcriptions of these records because they are so useful for local and family history. And I've just put down a few other central government records that moved from the medieval into the early modern period, which again stuffed full of names. Rolls of Parliament, Privy Council records, and most importantly the letters and papers of Henry VIII and Calendar of State Papers. This is when you have a change in the government system. Secretaries of State being appointed to look after broad portfolios who will have even more information about what's happening at a local level. Equally, the Crown commissioned surveys into landholding and people's rights, and I've listed a few of the ones here. Lots of people have a source of pride by saying that their ancestors are named in Doomsday. That's quite an achievement. I would wager that not many people will always find a Doomsday ancestor. But there are later successor surveys looking at landowners from an earlier period too. But I'd draw your attention to two particularly important Inquisition series of records. Inquisition's post-mortem. We're used to modern post-mortem inquiries, but the medieval sort had a very precise meaning. When a tenant-in-chief of the Crown died, the Crown wanted to know what land they held, and therefore what money the Crown could expect to levy from their ancestors, called a relief, so that they could then inherit those lands. And so the IPMs would be set up by an inquiry. The escheators, or the royal officials who were responsible for looking after land that had fallen vacant in this manner, impanelled a series of local dignitaries, often knights, to inquire what land was held by the dead tenant-in-chief in each area. So it would list all the manors they held, or the bits of land, how much they were worth, what rights they were held under, so how many knights this tenant-in-chief had to provide for the king's army, and also what rents they had to provide as well. And most importantly, you will find information about where this land had descended from, so who the parent would have been, and also who was the next heir, so who would inherit the land, and also how old they were. If they were under the age of 21, the lands would be taken into the Crown's hands under wardship until that next heir reached the age of 21, and then they would pay their relief and inherit the property. But until such time, that land could either be managed by the Crown directly or sold off so that someone else would manage that land and effectively enjoy all the profits. So IPMs are a great source for medieval and early modern inheritance around land. So it bridges the gap in many ways with some of those court records, the manorial sources that I mentioned earlier. Quite a lot of these have been calendared, so there are printed, indexed versions of them, but you can also search by name online via the National Archives website in their Discovery search engine. Inquisitions ad quodamnum are very similar, except these related to grants of land to the church. Now, bearing in mind land should pass from one individual to the next, there was a lot of concern in the late 13th, early 14th century that land donated to the church would never be brought back into the royal sphere of influence because the church never died. It was an institution. This was known as mortmain, or dead hand, the dead hand of the church, because it would continue. And so if people wanted to grant land to the church, often so that they would have alms said or psalms for their soul as they went through purgatory, the Crown would take an interest because it lost rights, it lost this ability to levy a relief. So it would hold an inquisition ad quodamnum. To what damage would this affect the Crown? Most of the time it was waved through because the person wishing to grant land then had to pay money to the Crown too. It's all about money in this period. And then there are a whole series of miscellaneous inquisitions granted by the Crown into local affairs where your ancestral names will appear. Most of these, again, at the National Archives. Finally, we'll have a quick look at law and justice, because the laws at this period were very harsh and many people fell foul of them, either through active wrongdoing or simply because they were in the wrong place at the wrong time. So we need to know a little bit about the justice and the legal system, in particular the jurisdictions that were in play. We had the Crown system, which picked up civil and criminal cases, but also there was a separate legal structure that related to forest law. Now, the forest wasn't just about how many trees grew near where you lived. This was a legal entity where the Crown had reserved land for hunting, and it protected everything that grew or lived in that area. Now often this was a new piece of forest that was created after the conquest, and it was highly controversial, so much so that when you have the great protest against King John and the creation of Magna Carta, there was a separate charter of the forest just to look at this particular issue. But many of our poor ancestors found that overnight they were living in forest and couldn't do certain things, and there was a whole separate judicial system that would fall down on their heads if they killed a king's beast, for example, because they were starving to death, or cleared a bit of land, known as an assart, to grow crops. Quite often they would have to pay a fine or financial penalty to keep the land or to cover the cost of the deer, but often they were hauled off and executed. This was really harsh stuff. Alongside Crown Justice, you would have local borough and manorial systems, as we've seen already, dealing with petty offences. And there was a whole separate ecclesiastical judicial code for people who could claim clergy, either because they were attached to the church or often were educated in the church and could recite Latin. So to claim clergy meant you had a more lenient system of justice, hence the great controversy between Henry II and Becket. We need to differentiate between civil cases between individuals and criminal cases by breaking one of the statutes, the royal laws, in which case you were hauled up before a royal justice in its various forms. But there were also different ways of dealing with cases brought before the courts. Common law, based on precedent, what had happened before, would determine the outcome of the case, hence large legal textbooks growing up showing you what had happened in a variety of cases. But also from the 14th century onwards, equity based on fairness, evidence-driven trials, where all sorts of things would be brought before the court, often relating to interpersonal disputes and often relating to inheritance. So this is where you'll find a lot of information about your ancestors. We have the central common law courts, the main one King's Bench, or Coram Rege, in the presence of the King, based in Westminster, hearing the most serious cases of the land. Equally common pleas, dealing with a lot of civil material. And here we have Palatinate courts. The Palatinates of Chester, Durham and Lancaster were established by the Crown, giving independent rights to the person who was in charge, often a member of the royal family, a duke, or indeed a leading ecclesiastical, such as the Bishop of Durham, who would look after the Palatinate. So they had their own court systems as well. But as well as these fixed courts, you had something known as the general air, a series of justices sent out around the country at regular intervals to hear civil and, in particular, criminal suits, taking business away from the borough and the manorial systems as the 13th century progressed. This was wound down usually after 1294, but were occasionally heard from the 14th century, and replaced by assizes. These were regular circuits of several counties where justices were sent out 2, sometimes 3 times a year to bring all the court cases together in one place. And there's a vast amount of material. There's a bit of a gap from 1482 to 1558, but from 1558 onwards you have a fairly regular set of records right the way through into the 20th century. They are in the National Archives ASSI series, and there's a table online that you can have a look at that shows you which county, for which date, for which type of record you need to consult. I think, though, that you'll have the most success in tracking ancestors in equity courts. This usually covered civil cases outside the remit of the common law courts, so often where there was no crime committed but there was a dispute, because it used a different process based on equity or fairness to generate a legal process. The first stage was for someone who felt that they'd been aggrieved to file a bill of complaint in court, setting out the grievance and naming the person or people who were at fault, or at least they thought were at fault. Those individuals would then be required to provide an answer to the charges, which would be written up and submitted to court as well, often refuting the grounds of the original bill of complaint, which would then require the original plaintiff to provide a rejoinder, saying how they thought that the answer was wrong. This process would continue, often over many stages, to refine the point of law and determine to the court exactly what was at dispute. An order may then be put out that evidence had to be gathered to support both sides. So interrogatories or questions were sent out to key witnesses in the local area, who'd then be asked to provide a written deposition, often in front of some of these local dignitaries, the knights of the shire, or affidavits in front of a lawyer, answering the questions and often providing evidence as well. And these evidences were brought together as exhibits and placed before the court. Now, the great thing is that many of these records still survive. The exhibits are particularly interesting because they often include title deeds, pedigrees, marriage settlements, copies of wills, all sorts of bits and pieces relating to family relationships that have perhaps gone wrong. And also, these disputes would go on for many, many years, often generations. And so we've got an incredible archive of litigation relating to family disputes. There were 4 courts that operated the equity system. The main one is Chancery, which was established in 1386, for which there's an enormous archive at the National Archives. Many of the pleadings, the bills and answers, rejoinders and replications are indexed by name, cross-reference to the plaintiff and defendant and any other named parties, and for the earlier records a summary of what the suit was about. You can search for these online using Discovery. There will also be links back into the Chancery interrogatories, evidences, and the Master's exhibits. Again, often by name, by dispute, and by the relevant material. There's a similar archive for Exchequer records. This also operated an equity suit system, but it tended to be people who were crown debtors. So it may well be a dispute about a debt owed to the crown relating to 2 parties, or a piece of land held from the crown. The Court of Requests was introduced from 1483 simply to lower the financial bar to get more people into the court system. Chancery pleadings was quite an expensive business. As you can imagine, teams of lawyers would pile in from both sides, raising the cost. So the Court of Request was meant to be a court for the poor, so they weren't excluded from justice. And Star Chamber also operated a system of equity, where bills of complaint could be directed to the highest authorities, often Crown or Council. So called because the sittings would take place in one of the rooms in the palaces with a painted ceiling that had stars all over it, so it took that name from the actual facility where the court was heard. So this is just a flavour of some of the records and styles of research that you're going to need if you want to track your ancestors back from, say, the 18th century into earlier records. There isn't simply time to go into that much detail for each and any one of them, and I haven't even touched on some of these other areas as well. We've looked primarily at landholding and officials, the interaction between individual and state. But if we're looking at private enterprise, then you might want to look at guild or livery companies linked to an apprenticeship system, where people would enter a trade, particularly in many of the towns and cities. Let's not forget that the medieval and early modern world was predominantly rural. The manorial system applied to most people, and you wouldn't have that many towns or cities. London was huge, vastly outnumbering any of the other provincial centres. 120,000 people by Tudor times. The next largest city may well be something like Norwich, for example, of 10,000 people. You could get the population of the next 10 largest cities into London. So you had a network of provincial cities with market towns around it. But those provincial cities would still have guild and livery companies who would take on skilled trade, taking in apprentices, and many of those have guild registries. Similarly, you will have freemen of the city being created and mayoral registers listing all the mayors who were elected or appointed throughout that particular corporation's history. So they're a great resource to try and pinpoint well-known ancestors. Universities and schools have alumni lists, people who passed through the system. Again, let's not forget that the main 2 universities for most of this period were Oxford and Cambridge, and many of their alumni records have been published online, going back into the 16th century or earlier. And if you didn't go into landholding or formal education, you may well take a career in the church. And there's a whole series of church archives. Church of England Archives Centre at Lambeth Palace, the Borthwick Institute at the University of York in Heslington have huge ecclesiastical archives that will also help pinpoint ancestors. And let's not forget the medieval and early modern times were very violent, and so you will have military ancestors, which is a whole new talk or webinar. There are all sorts of recruitment records by indenture, by hiring, accounts. You've even got people who were in the early navy from the 13th century recorded ship by ship, surviving in the records of the Exchequer. So, I guess in terms of final tips, start from modern times and work back. Mind your language and get all of those realistic expectations in place. Think about the nature of society that you're going into. And in many ways, you're switching from straight genealogy into more of a local history phase of your research. It may not be possible to always identify individual ancestors, but what you will be able to do is to understand through all of these records a bit more about the life and times and the society in which they lived. And that in its own right can be a fascinating insight into the world from which your ancestors emerged.